Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, Bryan Kohberger gets his change of venue request. Karen Reed, well, she's been in purgatory. The Donna Adelson case is beginning soon, which means there'll be pre-trial motions which shape how the trial will proceed. A former bad cop gets sentenced. Guess who he was trying to hang around? Another cop gets fired for not wanting to be a cop, and a young newlywed is murdered. And we have a new segment here at Crime Talk, ladies and gentlemen. It's called This Day in Legal History. Who knows? Maybe we'll all learn something. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below on everything that we talk about today. And hit that little bell for notifications. I know you say, gosh, why does he do this? But I'm telling you, I get more text messages and emails, DMs, where people are saying, I subscribe every day. I hit the little bell and I don't get notifications. So I ask you to go check that out so that you get notifications when we go live or put up new content. All right, let's go ahead and open the record for September 9th, 2024. And first on the docket today, Bryan Kohberger. That's right. Now, Judge has agreed to move the trial for Bryan Kohberger, obviously accused of stabbing to death 4 University of Idaho students, to a different city. Now, in the order that was actually dated Friday but released today, Judge said he was concerned about the defendant, Bryan Kohberger's ability to receive a fair trial at the Lake Talk County Courthouse there in Moscow, Idaho, given the extensive media coverage of the case, as well as statements by public officials suggesting that Bryan Kohberger was guilty. He also noted that the courthouse isn't big enough to accommodate the case and that the county sheriff's office doesn't have enough deputies to handle security. Now, Kohberger's defense team obviously filed the motion for change of venue, arguing that the strong emotions in the close-knit community and the constant news coverage will make it impossible to find an impartial jury in the small university town where obviously the killings took place. Prosecutors argued that any problem with potential bias could be resolved by simply bringing in a larger jury pool of potential jurors and questioning them carefully. Obviously, the judge disagreed. So let me tell you a couple of things, ladies and gentlemen. I went and looked at the judge's order. And let me tell you, no surprise here whatsoever. I've been saying this case needed to be moved from the beginning. A lot of people said, why? It needs to be tried there. Well, for all the reasons that I'm going to talk about is what I mentioned, and that's why the judge went along with it. They should have just asked Scott, and they could have got their answer rather quickly. But the first thing is the judge goes through his order and says, hey, we had a hearing on August 29th of 2024, right? And at the hearing, the defense presented expert testimony from James Todd Murphy, Dr. Amani El Alali, Dr. Brian Edelman, and Dr. Veronica DeHeer. The state did not call any witnesses. I told you this was a no-brainer last week that this was going to be granted because there's no evidence to contradict what the defense has put forward. The judge had to grant this, otherwise it would be plain air, ladies and gentlemen. So anyway, the court goes on. He spent several months, struggling with this hard decision. It wasn't a tough decision. It was easy, and it was easy because the prosecution didn't do a single thing, right? All those studies, all that groundwork that the defense did for their change of venue, the prosecution could have done the exact same thing, and they either chose not to or they did it, and it didn't turn out well, so they didn't, report it. The first is what took place. They just didn't do it. And so the court said, based upon the totality of the factors, the change of venue is granted. Now he goes through a little bit of the background, and they get to the facts. It's like, all right, despite efforts by the parties and the court to protect the jury pool from being inundated with information that is potentially prejudicial and false, extensive media coverage by mainstream media sources such as newspaper, radio stations, and television news outlets has continued throughout the state and nationally. Additionally, and perhaps more challenging, is the ongoing spread of prejudicial information, rumors, and patently false theories of the case on social media, on outlets such as Facebook, podcasts, and blogs. There's been numerous television shows and documentaries produced about the homicides, and at least one book has already been published. And the parties agreed that the case has generated extensive coverage by the media, internet sleuths, and others trying to capitalize on the tragedy, but disagree on how the court should attempt to remedy the issue to ensure Mr. Kohberger is tried to by a fair and impartial jury. Obviously, Kohberger says, change of venue. Prosecution says, just bring in more jurors here. It'll all be fine. And this is the important part, just like I told you last week after the hearing. Evidence. You have to present evidence, and the defense did in this particular case. As noted, the change of venue hearing, Kohberger presented expert testimony, and he lists everybody again. Kohberger submitted several exhibits depicting news stories, news clips, and social media posts for this case review. The state did not call any witnesses or submit any evidence. Goes on to talk about James Todd Murphy. Basically, he states that Mr. Murphy testified that this means that the media coverage in Ada County is much more diluted, while Latah is saturated in such coverage. Dr. Amani El Alali is a social psychologist and social cognition researcher, evaluates how publicity about a case can shape potential jurors' attitudes. First, Latah County authority figures have publicly spoken about Kohberger's guilt in absolute terms, like the prosecutor. The former Moscow Police Department chief, James Fry, who was the police chief during the investigation into the homicides, publicly declared he had no doubt that they have the right guy, and he had been arrested for the crime. After Kohberger's arrest, the University of Idaho president, Scott Green, stated publicly that the university community once again felt safe. Generally speaking, individuals are more likely to trust and believe authority figures, and so, therefore, it biases the defendant. Second, he goes on to, because Latah County is small, close-knit community, members feel a sense of loyalty to community and views all fellow community members as basically a family. Similarly, given the small size in Latah County residents had a much more emotional experience surrounding the homicide and therefore are much more invested in the case. Then they talk about negative publicity. And then obviously the Dr. El Alali opined that it was arguably impossible for residents of Latah County to be asked to serve as an impartial juror because they are biased against Kohberger, even if they don't want to be biased or think they are not biased. And this is particularly difficult for the defense to overcome because when humans process information while experiencing emotions like fear and anger, it's difficult to change that initial opinion formed even in the face of contradictory evidence. Instead, we as humans pay greater attention to information that backs up our initial preconceived ideas and opinion. And the court notes taken together in Dr. El Alali's expert opinion, the best way to ensure Kohberger is tried by a fair and impartial jury is to both physically and psychologically remove the case from Latah County. Now, Dr. Edelman, he's the one that did the survey, but based upon the survey, the doctor opined that his expert opinion, there's a reasonable likelihood the presumption of guilt prevails in Latah County. Then we had Dr. Veronica DeHeer, called by the defense to offer expert opinion as to the validity of the survey work by Dr. Edelman. As you may recall, the prosecution tried to undermined his methodology. At one point, even went to the court, and the court paused surveys that were taking place because the prosecution was all in a tizzy, that they thought that the defense couldn't do this, when in fact they could. And once the court figured out what was going on, they in fact did what they came here. Then the court went through, obviously, the standard, a motion for change of venue is at the discretion of the trial court. They talk about prejudice, actual prejudice, presumed prejudice, and when we get back to the convenience of interest of justice, even without finding a presumed justice, venue in this case must be changed for the convenience of the parties and witnesses in the interest of justice. While this issue was summarily addressed by the parties, the court has considered the logistics while the motion for change of venue was pending. First, the issue of safety and security for the parties, including the witnesses, victims, families, jurors, and the Latah community. The Latah County Sheriff's, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial and to perform their day-to-day duties. They also don't have enough clerks of the court to effectively manage the jury selection process, as it is anticipated that they are going to send out up to 6,000 jury summons in this particular case. So, just like who said it? Who said it last week, 2 weeks ago, 3 weeks ago, 4 weeks ago, when all these issues came up? Yes, this case was going to get moved. It was a no-brainer. I don't know why the prosecution just did not confess it. Finally, the court says, well, traveling to another county for 3 months is indeed inconvenience for the attorneys, the court, family members of the victims. Some witnesses having the trial at the Latah County Courthouse would also be inconvenient in numerous ways, and beyond that would present serious safety risks. The interest of justice requires that the trial be moved to a venue with resources, both in terms of personnel and space, necessary to effectively and efficiently handle the trial of this magnitude and length, so that the parties in the court can focus on the case and not on peripheral issues. We'll see you all in Boise next year, ladies and gentlemen. That's right, Boise. That's where it's going, Ada County. Now, the defense has also filed another motion to strike the utter disregard aggravator. This is basically death penalty litigation, attacking everything in this particular case, saying that the aggravator for the death penalty, that the prosecution must show that there were aggravating circumstances, that this wasn't just some, I hate to say it, some random quadruple murder. So to do that, the prosecution has argued that there are aggravating factors in this particular case, basically of the utmost callous disregard for human life and the cold-blooded, pitiless slayer. Cold-blooded marks the absence of warm feelings without consideration. Denied. That motion will be denied. I get what you're doing, defense attorneys for Bryan Kohberger, but that one is going to be denied. Next on the docket, Karen Reed tells ABC News she's in purgatory. That's right. Karen Reed, obviously accused of ramming into her then Boston police officer boyfriend, John O'Keefe, leaving him for dead back in January 2022 in a snowstorm. And obviously we know her trial ended in July, where a mistrial was declared. We don't even need to go into the deliberations because it was all nonsense. The jury should have said that they were able to reach a verdict on some of the charges, but not all of them. And so the judge just declared a mistrial. So now it'll be going through. Anyway, Miss Reed sat down for an interview, and it was on ABC's 2020 over the past weekend. And she says it just feels like she's in a purgatory. Now, she told ABC News that she felt an immense sense of dread as she searched for O'Keefe. And she acknowledged having 4 drinks that night, some of which she didn't finish, but she said that she felt fine. She says, I was worried he might have gotten hit by a plow. That was my first thought, Reed said when she spoke with 2020. It was the only explanation I could think of for why John's just disappeared into thin air. Now, obviously, a trial, which we brought to you, and we'll bring it to you again, the defense portrayed Miss Reed as the victim in this entire case, saying that Mr. O'Keefe, her boyfriend, the former police officer, was actually killed inside one of the Albert's home and then dragged outside. They argued investigators focused on Miss Reed because she was a convenient outsider, i.e. not a police officer, who saved them from having to consider law enforcement officers as suspects. There you go. Now, I think this is interesting. I'm not sure why the defense attorneys would allow Miss Reed to speak to the press. Anything she says obviously can and will be used against her. This is kind of what you consider self-serving hearsay. Very unlikely the prosecution is going to bring this in, but this is clearly an attempt by Miss Reed and her attorneys to influence the jury without her having to testify. As you may recall, she did not testify at her trial. Frankly, I don't think she needed to. I think there were lots of holes in the prosecution's case. Obviously, the jury wasn't totally convinced in at least one charge they think that she was guilty of. Anyway, my guess is that she is not going to testify again at her trial when it resumes. And this is their way of simply trying to tell her side of the story without having to be subject to cross-examination. Because everybody knows the mainstream media people don't exactly ask hard-hitting questions on anything. I could have a few questions for her on cross-examination, which I think would make her look not like such a good little victim, so to speak. But if I was representing her, that's exactly what I would do. But, like I said, ABC News, not exactly known for their hard-hitting news, ladies and gentlemen. So take it for what it's worth. Self-serving hearsay. It'll never be played in a court of law, other than maybe admitting that she was drinking. Now let's just take that. She said she had 4 drinks, ladies and gentlemen. As a general rule, 1 drink is 0.025, 4 drinks in an hour, 0.100, or 1.0, which is above the legal limit of 0.080, and therefore, so she would have been legally intoxicated. And obviously, if you're legally intoxicated and you hit somebody and they're drunk, it's vehicular manslaughter. Just throwing that out there. Just throwing that out there. And even if you didn't consume them all, depending on how much you eat, she's very tiny, depending on your ability to consume alcohol, you may feel fine, but your BAC levels will be up there. Just something to think about, ladies and gentlemen. Think about it. Let me know if you think I'm wrong. Just like a lot of people told me I was wrong on the change of venue motion. And I love it when the people tell me, you're an idiot, Scott. You don't know what you're talking about. And then I was like, oh, maybe I do. And maybe a lot of those other channels out there that are literally just trying to come up with the most outrageous thing to get people to talk about stuff, maybe we like to focus on the facts. Fact-driven. That's what we try to do. Next, Donna Adelson. Remember her? Yeah, she's accused of conspiring with her son, Charlie, to kill a brother-in-law, her son-in-law. Anyway, her son, Charlie, was a wealthy South Florida periodontist and conspired with his ex-girlfriend, Magbuna, and coordinated with hitman, a guy by the name of Garcia, and another guy by the name of Rivera to carry out the murder. Now, Markle, the son-in-law, was gunned down while pulling into his Tallahassee driveway back in July of 2014. So Charlie, Magbuna, Garcia, and Rivera were all convicted. Now, Donna Adelson was arrested exactly 1 week after Charlie's conviction back in November of 2023. She was arrested on a jetway while trying to board a plane from Miami to Vietnam with a one-way airline ticket. Yeah, because that's normal, right? Flight, consciousness of guilt, ladies and gentlemen. Anyway, there was a motions hearing because we have pretrial issues coming up, and they frame basically what evidence is going to come in. Well, the defense presented a motion in limine regarding the testimony of a Tallahassee police officer by the name of Sergeant Christopher Corbett. Now, prosecutors want Corbett to testify about call detail records for Donna Adelson, Charlie Adelson, Wendy Adelson, Harvey Adelson, Catherine Magbuna, and Sigfredo Garcia and Luis Rivera. Now, the call detail records are files containing information about communication activities among phone calls and text messages. The information is usually derived from cell phone towers and telephone exchanges. The telephone exchanges is the physical building where the connections between the phone lines are established. Anyway, Donaldson Adelson's defense team, Daniel Rashbaum, argued that while Corbett should be allowed to be a summary witness, he should not be qualified as an expert witness. And Sergeant Corbett's report contains things like text messages and emails. And Rashbaum explained that, but the sergeant simply compiled them and cannot provide expert-level testimony, i.e. trying to interpret them, what that means, based upon my training and experience, that kind of stuff. Anyway, the judge ruled to partially allow some of the testimony in from Sergeant Corbett. As to whether Corbett can be qualified as an expert, the judge clarified that while the sergeant is capable of interpreting these records, his testimony would be demonstrative and would not be admitted as expert testimony. Now, the judge also expressed some interest in the hearing about how Sergeant Corbett put his summary together and how he ultimately formed his opinions. Now, another motion in limine presented by the defense concerned the testimony of Wendy Adelson, who changed her son's last name from Markle to Adelson soon after their father's murder. Wendy also authored a fictional book that closely resembles her real life, and the judge noted that the name change can only be used to impeach Wendy as it relates to her prior testimony. In other words, prosecutors can ask Wendy about the name change only if it relates to her previous testimony on that exact topic. The defense has wanted the prosecution to be prevented from asking such questions, such as, did you change the kids' names? The judge said it would be permitted if it was related to motive. Now, whether it can be used for impeachment purposes remains to be seen, and we'll have to wait and see how the testimony comes out. It's also not clear yet if Wendy or Donna's husband, Harvey Adelson, will face any charges related to Markle's death. Now, the judge also addressed a motion regarding the admissibility of jail phone calls between Donna and Charlie Adelson, and the state announced that as of now, they have no plans to introduce any calls featuring Charlie. The final outstanding motion addressed with the judge was Luis Rivera's gang affiliation and prior bad acts. The state argued that the naming the gang organization would present credibility issues. For example, if Donna decided to take the stand and say something like, a member of the Latin Kings threatened me, it wouldn't be necessary to call out the specific gang, as it would effectively affect her testimony either way. The judge also stated that he is still mulling the defense motion to exclude hearsay testimony of Wendy's ex-boyfriend, Jeffrey LaCase. Now, before concluding the hearing, the judge reminded Donna Adelson that if she intends to entertain a plea offer, she needs to act fast. The final pretrial hearing is set for September 12th. Next on the docket, former bad cops doing bad things. That's right, a former North Carolina police officer by the name of Eric Douglas Lee showed up to a courthouse Friday on child sex charges a day late, but he still was allowed to receive a plea deal. Now, I bring that up because oftentimes one of the conditions of the plea deal is that your client not commit any law violations between now and the plea or sentencing, but also that they don't fail to appear. Otherwise, the plea deal goes away. Anyway, the former cop / former church volunteer failed to show up Thursday for what was supposed to be his guilty plea, and he was supposed to be immediately remanded to start an 8-year sentence. But on Friday, he received a sentence of 9 years, 1 year longer because he missed court. Now, Lee was the volunteer leader of a youth group at the Morning Star Fellowship Church in Fort Mill, North Carolina from 2020 to 2023. And Lee used that status to abuse boys, according to prosecutor. And Lee coerced and intimidated the boys at the Fort Mill home while giving them alcohol and vapes, showing them porn and sexually touching them. This was over the course of several years. Now, the same thing apparently happened to minors multiple times, according to the prosecutors, but the police there in Cornelius, North Carolina, did their job, and he was obviously arrested back in April of 2023. Now, 4 victims were in court but didn't speak. All 4 had been at court Thursday for hours waiting to see if Mr. Lee was actually going to show up. He didn't. And a written statement from the victims and their families read in court described Lee as a predator and a master manipulator. Anyway, the deputies arrested Mr. Lee on a bench warrant Friday morning when he arrived at the courthouse. The judge vacated the bench warrant after Lee pled guilty, and prosecutor and Lee's lawyer negotiated the 9-year sentence on 5 of the 11 charges, and they dismissed the remaining. And the judge, like I said, had to have an additional year to go along with the deal. Always show up for court, ladies and gentlemen. Anyway, Mr. Lee pled guilty to 2nd and 3rd degree criminal sexual conduct with a child, 1st degree assault and battery, dissemination of obscene material, and contributing to delinquency of a minor. It was an Alford plea where the defendant does not have to admit guilt, but everybody knows he's pleading guilty, but accepts the evidence as has a strong likelihood that he could be convicted at trial. Anyway, I really don't like Alford pleas because people do that to kind of get out of it. If you plead guilty, the judge should say, I'm only going to accept it if you tell me you are in fact guilty. So tell me in your own words what you did there, Mr. Lee. Anyway, 9 years in prison for the former cop who wanted to hang out with kids at church. Next, another police officer. He has been fired for not wanting to serve the public. So apparently there was a fatal hit and run accident, and it cost the police officer his job, which it should. Because what did he do? He left the scene while the victim was dying on the street. So Esmat Ketter, this woman, she was out riding her electric bicycle past police headquarters on Washington Avenue down there in Florida when she was struck from behind by a blue Ford Bronco, which sped off without stopping. Seconds later, onlookers flagged down the first police car that was driving by, and it was a Miami Beach police officer, and the officer was a guy by the name of Edward Cavalier. Anyway, who was in this police car, but when he told the people to find somebody else when asked for help by the citizens, he then drove away. Now, when his colleagues arrived on the scene, guess what? There wasn't much they could do for the woman who had been declared dead on arrival at the hospital. Needless to say, the officer has been fired, and Cavalier has only been with the police department for less than a year when this crash took place back in April of this year. Now, the Bronco, the one that also fled, was driven by a guy by the name of Demarius Cortez Harrington, who clipped the bike rider, throwing her into the curb where she hit her head. Now, Harrington reacted apparently quite fiercely, insisting that he was not going back to jail, and left his friends afraid that he would possibly even shoot or kill himself if he spoke to the police. Anyway, Mr. Harrington ditched the Bronco and left the scene on foot. Took officers 2 months to track him down and charged him with leaving the scene of an accident resulting in death. What can you do, ladies and gentlemen? It's one thing for the everyday world to be callous and not want to do anything to help their fellow man, but it's definitely not good when the police officers who are there to protect and serve say, go find somebody else. You can't make this stuff up, ladies and gentlemen. Next, murder of a newlywed. That's right. The search for a missing newlywed from Oregon concluded this week when police recovered her remains and charged her neighbor with murder. So on Saturday, September 7th, the Beaverton Police Department announced in an update that Melissa Jubain, a 32-year-old nurse who was reported missing 3 days earlier, had been found dead. The discovery came just days after her August 24th wedding ceremony in Hawaii, and police initially received a welfare check request about 10:10 a.m. on September 4th for Jubain, who worked at the St. Vincent Hospital in Portland. Didn't show up for her work, and her co-workers and friends, obviously, and family became quite concerned. Anyway, the Beaverton police then said that Jubain was not present at her home, and her absence without communication was deemed quite unusual. So after unsuccessful attempts to get in contact with Jubain and no location information coming from her bank or credit card history, she was listed as a missing person that afternoon. Well, Bryce Jonathan Schubert, Jubain's neighbor, is now believed to have been involved in her disappearance following an investigation. He was arrested and charged with her murder on September 7th, and the remains have been recovered. Now, Jubain and her husband, Bryan, tied the knot in August of this year, and they stayed at their Oregon apartment, and it was close to her work, while Bryan stayed with her family in Washington State, apparently. Now, Jubain did not return to work on September 4th, and her husband last heard from her about 6 a.m. that morning. He says there was simply no Melissa. Her bag, wallet, and keys are missing, and her car is still parked in the parking garage. All right, so Schubert's charges include second-degree murder. We'll follow that one. Just weird. Probably some weird, creepy neighbor. I don't know. But I'm sure more information will come out. And he did something inappropriate with her and killed her in the woods and buried her in a shallow grave. That's my guess. All right, next, a new segment that we have here on Crime Talk today, On This Day in Legal History. I think this may be enjoyable. I hope you enjoy it. So first, on September 9th, 1998, independent counsel Kenneth Starr, who passed away, I think, last year, filed a report to Congress accusing President Bill Clinton of 11 impeachable offenses relating to his association with the then White House intern, Monica Lewinsky. That's right, all those years, and guess what? All those names are still around. On September 9th, 1836, future U.S. President Abraham Lincoln received a law license to practice law there in Illinois by the Illinois Supreme Court. He's setting up a small office in Springfield, Illinois. He filed his first lawsuit less than a month after receiving his license on October 5th. Yesterday in legal history, just because, let's give you as much as we can. So on September 8th, 1974, 1 month after taking office, President Gerald R. Ford granted a full, free, and absolute pardon to former President Richard Nixon for any crimes allegedly committed during Nixon's presidency. And finally today, our dumb criminal of the day. An Ohio woman apparently stomped a cat to death before beginning to eat the animal, according to police reports. Now, as alleged in the municipal complaint, Alexis Farrell killed the cat by stomping its head outside of a public housing complex in Canton, Ohio. When police responded Friday evening to the incident, there were multiple witnesses who found Farrell squatting next to the dead cat. According to the police report, Miss Farrell had blood on her feet and hands and fur on her lips. There were also people at the scene saying that she was eating the cat. Now, no one knows who owned the cat, but it was taken away by animal control. Anyway, Miss Farrell had previously been arrested on several felony misdemeanor counts and booked into the county jail, where she's being held on a $100,000 bond. She is scheduled for a preliminary hearing on August 26th. Now, like I said, Miss Farrell's rap sheet includes multiple theft convictions, as well as a 2023 felony conviction for child endangerment. And since we go the extra mile for you here at Crime Talk, look, actual video of the police arriving, and they're saying, what was she doing? And people are saying, she was eating the cat. That's not normal, ladies and gentlemen. That's not normal. All right, that's all we have for you today. Thanks for joining us. Hope you enjoyed the show. We'll see you next time, and remember, the Constitution matters.